are outside the presence of the jury, the attorneys from both sides, as well as the defendant present. We'll proceed to the court's preliminary instructions and then determine opening statements. Just to be clear, I permitted the media to utilize a pool camera, so for openings, closings, and then for audio only during giving of the verdict, the media has permission to cover those portions of the proceedings. For those of you who were here last time, it's effectively the same rules as the last time. Is there anything further from either side then before we bring the jury in?
No, Your Honor.
Patrick?
No, Your Honor.
Strauss.
Yes, Your Honor, just a few evidentiary matters that I discussed with the prosecution after we concluded last night. It may bear on the opening statements, and so I just wanted to bring it to the court's attention and we can go from there. The first is that I had a conversation regarding the intended scope of the evidence that the prosecution expects to elicit from a couple of their witnesses. And I think we have agreement on one of them. For Mr. Marcy's testimony, it appears that the prosecution is not going to be eliciting evidence of Mr. Brooks's release date. That did happen at the October trial. I inquired about it. My understanding is that they agreed not to elicit that evidence. That understanding, I'm not going to move to preclude it, but I would move to preclude it if they were going to try and elicit it.
All right.
What else? The other issues have to deal with Dr. Merkulova, who's the medical examiner. The first is, and we do not have agreement on this issue, is that I would be objecting to the prosecution eliciting testimony or even mentioning an opening statement that her conclusions or opinions would be that Mr. Brooks died from a homicide, or that the manner of death is a homicide. Fourth Department authority on that issue. A couple of different cases. People be, I can't pronounce this word, this title, SZANTANEK 169, 83rd, 1448, 4th Department, 2019. I have a copy of that opinion here for the court.
Yeah, can I have a copy of that?
And Your Honor, I'm handing out just a summary memorandum that addresses that issue as well as these remaining issues with Dr. Merkulova that I discussed with the prosecution last night. I've handed a copy of this memorandum to the people as well. And there's a copy of the also the 4th Department case, People v. Campanella. And the 4th Department has held that the medical examiner's conclusion or opinion, testimony that the cause of death is homicide and the manner of death is homicide is improper because it is the province of the jury. And so we moved to preclude it on that basis. And I understand we're dealing with a homicide charge, but I'm only seeking to preclude the opinion testimony in reference to that from Dr. Merkulova. And then there's a couple other issues with Dr. Merkulova. I can proceed with my report.
All right, let's deal with the issue you just raised. Mr. Fitzpatrick, what's your position with respect to the question of whether or not your expert can state an opinion that this involved a homicide?
Judge, as you know, as a former homicide prosecutor, there are 5 options for a medical examiner to check on an official state form regarding the manner of death. Homicide, undetermined, natural, suicide, or accident. The cases cited by Mr. Eisman have to do with situations where the court is confusing the phrase homicide with murder. I'm not asking Dr. Merkulova to testify that this is a murder. I'm going to ask her to testify that the manner of death was homicide, i.e., Mr. Brooks died as a result of the agency of other people. And he suffered a myriad of wounds that led to his death. That in no way is usurping the province of the jury. And there are a number of cases, Your Honor, that cite expert opinion as being admissible in this type of situation. People versus Rivers, which is a generic case from the Court of Appeals, 18 New York 3rd, 222. Do you want me to give you any more cites, Judge?
That's it.
Okay.
All right, so we'll deal with these issues then one at a time. The court will permit the prosecution to make reference to their witness's opinion if, in fact, the witness's opinion is that the manner of death was homicide. What else do you have, Mr. President?
At the October trial, the prosecution listed evidence, an opinion from Dr. Merkulova about the possible effects that K2 would have had on how Mr. Brooks was feeling at the time that he was being assaulted. Essentially, that it would have reduced his pain, his level of pain. That was not noticed in the autopsy report as an expert opinion, so I'm objecting on that opinion as being improperly noticed in the first stage. In the second stage is, I don't think, as I laid out in the memorandum, I don't think it's backed up by appropriate foundation. But I would like to voir dire on that if the court is going to permit them to elicit that testimony. But primarily it wasn't noticed, and I don't think it's appropriate for them to elicit that opinion.
Mr. Fitzpatrick.
We have the ability here of knowing what she's going to say. All three of us, you and I were present. Mr. Eisman, you may have been present, but he certainly has the transcript. So she would say, if allowed, that part of her autopsy was to review the toxicology report. In the toxicology report, it indicates that despite the fact that he was in a correctional facility, Mr. Brooks had at some point in the past injected a synthetic opioid, K2. The only thing that she's going to say is that that may have ameliorated the pain that he was suffering during the beating. Frankly, I don't see how that's in any way prejudicial to the defense. And I think to give a complete picture to the jury, she should be allowed to testify to that.
Provided our foundation is the court will permit the same. Did you have something else, Mr. Eisman?
Just a little bit more on that point, Your Honor. I think there's a distinction between saying that the K2 did not contribute to the cause of death versus the separate, additional, and distinct opinion that it would have ameliorated the pain at a particular time. I think those are distinct opinions. The latter is not noticed, the former is. I would not object to a question when he said, did it have anything to do with the cause of death? No. I think that would be appropriate because part of our autopsy is appropriately noted. The additional opinion is separate and distinct, is not noticed, and that's the basis of my objection.
Duly noted. I'm going to permit it. Did you have something else?
Yes, sir. There was testimony at the October trial that certain pattern injuries.
Say that again, please.
There was testimony at the October trial elicited from Dr. Merkulova that a certain pattern, P-A-T-T-E-R-N injuries or injury was consistent with a shoe strike. And again, same objection that was improperly noticed as an opinion in the autopsy report. She also testified at the October trial that she was not able to determine the source of that injury based upon autopsy. And so I've referenced in my memorandum and provided the trial transcript where she testified to that. Nonetheless, she testified that the pattern was consistent with a shoe. And so I would object to that opinion, the prosecution being allowed to elicit that opinion on it being unnoticed as well as a foundational basis.
Mr. Fitzpatrick.
I think it would go to the, not to the admissibility, but to the weight of the admissibility. She's going to clearly say, I can't say for certain that this is a shoe. But what Mr. Eisman didn't mention is that we have videotape of an officer striking him with a shoe. So I think she should be allowed to testify.
Yes, as do I. The court will permit the same, assuming the proper foundation is laid, but of course the defense may cross-examine thoroughly on that issue. Do you have anything else, Mr. Eisman?
Last one, Your Honor, and this is that I think we have agreement on this issue, but it has to do with the scope of the opinion. And my understanding is that the prosecution is not going to elicit any opinion from Dr. Merkulova that Mr. Brooks' death may have been avoided if medical assistance was rendered at any particular time. And Mr. Brooks' death may have been avoided if Mr. Brooks could have received certain medical procedures or treatment, and what said procedures and treatment are, and that certain force or combinations of force observable in Mr. Fisher's body on camera or otherwise visible to Mr. Fisher place Mr. Brooks at a substantial risk of death, that they're not going to elicit opinions from Dr. Merkulova on those issues.
Is that correct?
That is incorrect. It's the exact opposite. And I apologize if Scott misunderstood me. Dr. Merkulova, as an offer of proof, based on my prepping her for trial, will testify that Mr. Brooks was salvageable up until the time CPR started when his heart stopped. Prior to that time, over the 15 minutes of this meeting, if intervention had occurred, he may have lived. That's the essence of our case.
And that's not noticed, Your Honor, in the opinion. Their report consists only of the autopsy report, which says what the cause of death is and nothing more. It does not say, and there's no opinion rendered on what the basis of that opinion is, that Mr. Brooks was salvageable at any particular point in time, or what the nature of how he would be saved would be. It is not disclosed. It's not noticed.
About the notice.
I would disagree completely with that assessment. She has been consistent in the autopsy report. She's not bound to the four corners of her autopsy report. She's an expert. She can elicit opinions based on direct and cross-examination. But most importantly, in her autopsy report and in her testimony, she has consistently said that this death was a result of a series, an accumulation of injuries, one after the other, each one putting additional stress on his heart, each one taking blood from his brain, each one clogging his breathing passages. She has consistently said that. Grand jury testimony, autopsy report, and trial testimony. And I anticipate that that's what she will testify to this week.
There's a distinction between the cause of death being the result of the following acts or conduct or trauma. That is one opinion. The other opinion is at a particular point in time, he would have been saved, and then how and what the manner of that life-saving medical care would have been. Those are distinct opinions. I agree that the former is noticed, that the cause of death, the accumulation of the beatings, is properly noticed. I have no objection to that testimony whatsoever. I do have significant and serious objections to any elicitation of, at this point in time, he would have been salvageable, or here's what needed to be done to save him. That has not been noticed. It's nowhere in the grand jury testimony. It is nowhere in the autopsy report. And for the prosecution to elicit those opinions is not proper.
All right. I consider the arguments of counsel here this morning. I'm going to permit the proposed testimony, assuming proper foundation is laid. I think you're at some point here just splitting hairs and drawing lines where they don't belong drawn. I think the opinion that's been proffered that I expect to hear from the doctor falls within the scope of the report that she's prepared to issue. Is there anything further?
No, Your Honor. Thank you.
Secretary. Jury order. Welcome back, ladies and gentlemen. Everyone may be seated. Now, members of the jury, we are about to proceed with the trial of the case of People versus Michael Fisher. At the outset, I'm going to explain the various stages of the trial and what you may expect to see and hear during the trial, so that you may better understand what is taking place. I will also remind you of some basic principles of law which apply to this and to all criminal trials. At the conclusion of the case, I will again remind you of those principles. I will then define for you the crime charged, explain the law that applies to the charged crime, and list for you the elements that people must prove beyond a reasonable doubt. Remember, during jury selection, I explained that elements of a charged crime is a term that refers to the various parts of our law's written definition of the crime, in addition to the identification of a person as the one who committed that crime. Now, as you can see, we have a court reporter here taking down everything that is being said. And what she's taking down is called the record of the trial. Sometimes you may see a witness use their hands to illustrate something during the trial. For example, the witness may say that an object was this long and then use their hands to demonstrate for you. Normally, you would then hear the lawyer or the court say something like, "Let the record reflect that the witness has indicated approximately 1 foot." We do that because sometimes it becomes necessary to have the court reporter read back what a witness says and what the witness was indicating. If someone did not state orally for the record what a witness was then indicating with their hands, when that portion of the record is read back, you would not know what the witness was indicating. You, of course, will be able to see for yourselves what the witness is indicating, and you may make your own judgment in that regard. Now, the trial will formally begin with what the law calls an opening statement by the prosecutor. The law requires the prosecutor to make an opening statement. The law, however, does not require the defendant to make an opening statement. If the defendant does not make an opening statement, that is not a factor from which you may draw any inference unfavorable to the defendant. And remember that what the lawyers say in an opening statement or at any time thereafter is not itself evidence. The lawyers are not witnesses. Also, what I say is not evidence. I am not a witness here. In other words, you must decide the case on the evidence, and what the lawyers say at any time is not itself evidence. After completion of the opening statements, the prosecution will then proceed with presentation of evidence. I remind you, the indictment itself is not evidence. It is simply a document that contains an accusation. Defendant has pled not guilty to that accusation, and this trial is for you to hear the evidence and decide whether the defendant is guilty or not guilty. I remind you also that evidence is the testimony of the witnesses, the stipulations, if any, agreed to by the parties, and documents or physical objects that are formally received into evidence. Now, testimony is, of course, the most common form of evidence, and that comes from the questioning of the witnesses by the lawyers and perhaps by the court. A question by itself is not evidence. It is the question with the answer that constitutes evidence. For example, sometimes a question will assume something to be true. You are not, however, to conclude that an assumption in a question is true unless the answer in your judgment confirms that it is true. So you must consider the question with the witness's answer and decide whether you find that answer believable and accurate, because again, it is the question along with the answer that is the evidence. Next, evidence may come in the form of a stipulation. A stipulation is information which both parties agree to present to the jury as evidence without calling a witness to testify to that information. And lastly, evidence may come in the form of physical objects, such as documents, photographs, clothing, charts, and things of that nature. Now, when the lawyer is questioning a witness and refers to a physical object for the first time, the object is normally marked with a number or letter of the alphabet so we can more easily identify the object and refer to it. That procedure helps keep track of physical objects. It is the responsibility of the court reporter to physically write an exhibit number or letter on the object or on a label attached to the object. It is the responsibility of court personnel to keep an accurate listing of such exhibits. Normally, when the object is first referred to, the lawyer will ask the court to have the object marked for identification. If the people make that request and the court grants the request, then the object is marked with a number. If the defendant makes the request and the court grants the request, then the object is marked with a letter of the alphabet. And that distinction simply helps us remember who it was that introduced that exhibit. Now, an item that has been marked only for identification is not yet evidence. It is therefore not available for your inspection and consideration. However, sometimes the lawyer will ask the court to formally receive the object into evidence. When the lawyer does that, the other lawyer is then permitted to ask the witness questions to determine whether the object can, under our law, be admitted into evidence. If I grant the request to admit the object in evidence, then the object becomes evidence and it is then available for your inspection and consideration. Any small objects, which may may be hard to see, will be displayed for you by way of a digital projector or passed around and shown to you by a court officer. If ever during your deliberations you would like to see an object that's been received into evidence, you can do so by simply asking me to see that particular object. Now, an example of a document that may be marked for identification but not received into evidence is as follows. Sometimes a witness will be asked a question and then answer that they cannot remember what is being asked for, but that they may be able to refresh their recollection if given an opportunity to examine something. Usually that's a document. The witness may then be given the document and permitted to read it silently to themselves. If that document refreshes the witness's recollection, the witness will then answer the question, and that question, along with the answer given, constitutes evidence. The document that was used to refresh the witness's recollection may be marked for identification, but in most instances, the document itself will not be received into evidence, and therefore will not be available for your inspection and consideration. However, the question, along with the answer that the witness gave, will be evidence for your consideration. I will tell you that it is common and permissible for a lawyer or an investigator for a lawyer to speak to a witness about that witness's testimony before calling the witness to the witness stand. Also, a witness may review documents and other material pertaining to the case before they testify here at trial. Generally, a witness who is scheduled to testify at trial may not be present in the courtroom during the testimony of other witnesses. After the people have completed the presentation of their evidence, the defendant may, but is not required to, present evidence. And I remind you that throughout these proceedings, the defendant is presumed to be innocent. As a result, you must find the defendant not guilty, unless on the evidence presented at this trial you conclude that the people have proven the defendant guilty beyond a reasonable doubt. That a defendant does not testify as a witness is not a factor from which inference unfavorable to that defendant may be drawn. The defendant is not required to prove that he is not guilty. The defendant is not required to prove or disprove anything. To the contrary, the people have the burden of proving the defendant guilty beyond a reasonable doubt. That means before you can find the defendant guilty of a crime, the people must prove beyond a reasonable doubt every element of the crime, including that the defendant is the person who committed that crime. The burden of proof never shifts from the people to the defendant. If the people fail to satisfy their burden of proof, you must find the defendant not guilty. If the people satisfy their burden of proof, you must find the defendant guilty. Now, the law uses the term proof beyond a reasonable doubt to tell you how convincing the evidence of guilt must be to permit a verdict of guilt. The law recognizes that in dealing with human affairs, there are few things in this world we know with absolute certainty. Therefore, the law does not require the people to prove a defendant guilty beyond all possible doubt. On the other hand, it is not sufficient to prove that a defendant is probably guilty. In a criminal case, the proof of guilt must be stronger than that. It must be beyond a reasonable doubt. A reasonable doubt is an honest doubt of a defendant's guilt for which a reason exists based upon the nature and quality of the evidence. It's an actual doubt, not an imaginary doubt. It is a doubt that a reasonable person acting in a matter of this importance would be likely to entertain because of the evidence that was presented or because of a lack of convincing evidence. Proof of guilt beyond reasonable doubt is proof that leaves you so firmly convinced of the defendant's guilt you have no reasonable doubt of the existence of any element of the crime or of the defendant's identity as the person who committed the crime. In determining whether or not the people have proven the defendant's guilt beyond a reasonable doubt, you should be guided solely by a full and fair evaluation of the evidence. After carefully evaluating the evidence, each of you must decide whether or not that evidence convinces you beyond a reasonable doubt of the defendant's guilt. Whatever your verdict may be, it must not rest upon baseless speculations, nor may it be influenced in any way by bias, prejudice, sympathy, or by a desire to bring an end to your deliberations or to avoid an unpleasant duty. If you are not convinced beyond a reasonable doubt that the defendant is guilty of a charged crime, you must find the defendant not guilty of that crime. If you are convinced beyond a reasonable doubt that the defendant is guilty of a charged crime, You must find the defendant guilty of that crime. Now, our law recognizes that two or more individuals can act jointly to commit a crime, and that in certain circumstances, each can be held criminally liable for the acts of the others. In that situation, those persons can be said to be acting in concert with each other. Our law defines the circumstances under which one person may be criminally liable for the conduct of another. That definition is as follows. When one person engages in conduct which constitutes an offense, another is criminally liable for such conduct when, acting with the state of mind required for the commission of that offense, he solicits, requests, commands, importunes, or intentionally aids such person to engage in such conduct. I will instruct you further on this subject at the end of the trial. Now, each witness, by whomever called, is first examined, meaning asked questions by the lawyer who called that witness to testify, and that is known as direct examination. When the direct examination is completed, the other lawyer is then permitted to ask questions of that witness, and that is known as cross-examination. You may then have redirect examination and recross-examination, but the scope of such additional examinations is limited on the basis that the lawyers had sufficient opportunity on their original direct or cross to ask whatever they wish. The lawyers are responsible for questioning the witnesses. The court may ask a question of a witness. Jurors may not ask questions of a witness. Also, you will not be permitted to take notes during the trial, and as a practical matter, there is no need to. Remember that every word of each witness is being recorded by our court reporter, and during deliberations upon your request, testimony will be read back to you in whole or in part. As judges of the facts, you alone will determine the truthfulness and accuracy of the testimony of each witness. You must decide whether a witness told the truth and was accurate, or instead testified falsely, or was simply mistaken. You must also decide what importance to give to the testimony you choose to accept as truthful and accurate. And remember that it is the quality of the testimony that is controlling, not the number of witnesses who testify. There is no particular formula for evaluating the truthfulness and accuracy of another person's statements or testimony. You bring to this process all of your own varied life experiences. In life, you frequently decide the truthfulness and accuracy of statements made to you by other people. The same factors used to make those decisions should be used in this case when evaluating the testimony. Now, there are rules for all stages of a trial, including rules as to whether certain evidence may be introduced, and if so, how and when. And part of my job is to enforce those rules. Some of these rules you may understand when you hear the ruling. Some of them you may not understand unless you have studied our law. These rules have been carefully developed over hundreds of years for the sole purpose of guaranteeing a fair and orderly trial. In other words, these rules are not designed to determine whether the evidence you hear and see is true or false, accurate or inaccurate. It is for you, not me, to evaluate the evidence and make that decision. These rules are designed to ensure that the evidence you hear and see is relevant and is presented to you in a form that allows you to evaluate it fairly. I'm now going to explain briefly some of the rules that are commonly applied during a trial, so you will better understand the court's ruling when it is made. You will appreciate that the purpose of these rules are to ensure a fair and orderly trial. The witness usually can testify only about matters the witness has personal knowledge of. That is something the witness has personally seen, heard, felt, touched, or tasted. Thus, a witness is not permitted to guess or speculate, or say what they think another person saw, heard, felt, touched, or tasted. Also, a witness is not permitted to give an opinion about matters for which a special expertise is necessary, unless the witness purports to be an expert on the matter they are being questioned about. With some exceptions, what a witness may have been thinking when something was taking place is not relevant evidence. And finally, a witness is often not permitted to testify to hearsay, meaning generally that a witness cannot testify to what the witness or someone else may have said before the trial. But there are many exceptions to the hearsay rule for a variety of sound reasons, too numerous to detail for you now. I will, however, explain a couple of exceptions that do frequently arise during a trial. Sometimes the witness will be permitted to testify that the witness did something because of what someone said. In that circumstance, it does not matter who uttered the statement, or how the speaker gathered the information for the statement, or even whether the statement is truthful and accurate. It matters only that someone uttered words and the witness did something upon hearing those words. So in that instance, you may not consider whether the witness was told for the truth of the words said to the witness. You may consider the words only for the reason they are offered, and that is to explain what the witness did after hearing the statement. In limited circumstances, our law permits a witness to be asked whether that witness made a statement about the case before testifying during trial. If such a question is permitted, the law requires that the questioner inform the witness of the time, date, place, and content of the prior statement in order to permit the witness an opportunity to recall whether he or she made the prior statement. If the statement were made in a legal proceeding and there is a transcript of that proceeding, the law requires that after questions establishing the time, date, and place, the questioner asks the witness whether they were asked the following question and gave the following answer. And then the lawyer will read the purported question and answer, and the witness should say yes or no. Sometimes a person to whom the alleged prior statement was made may be a witness at trial and may be asked whether such statement was in fact made to that person. Often a lawyer will ask the court to receive in evidence items, such as a photograph. Under our law, to have a photograph admitted into evidence, it must be shown that the photograph is a fair and accurate depiction of the area in question at the time in question. If that is done, it does not matter on the question of receiving the photograph into evidence who took the photograph nor when it was taken. Now, in this case, images of the deceased may be admitted into evidence. You may understandably find such images upsetting, but if you do, remember, you have promised to be fair. If at the end of this case, after you have evaluated all of the evidence, you decide that you have not proven the defendant guilty of a charged crime, then you must find the defendant not guilty. You must not hold the defendant responsible just because you find photos or video upsetting and believe a serious crime took place and that someone must pay for that crime. During the presentation of evidence, the lawyers for the parties will in turn be asking questions of the witness. During that questioning, a lawyer is not permitted to make comments on the witness's answer or on the case generally. That often happens in television shows and in the movies because they only have a short period of time in which to convey the story. But in real trials, that is not allowed. In a real trial that is at the end of the case, the lawyers are then permitted to address jurors in what is known as a summation. And it is then that the lawyers may comment on the witnesses, the testimony, and the other evidence. During the questioning of a witness, if a lawyer believes the question or some form of evidence is not in accord with a rule of law, then that lawyer will object. When an objection is made, I will decide whether the rules permit the question to be asked or the evidence to be introduced. Making objections is part of a lawyer's job. You are not to draw any unfavorable inference because objections are made. They do take place at every trial. Now, a lawyer may object before a witness answers a question or after a witness answers a question. When an objection is made to a question before the witness answers, if I overrule the objection, the witness will be permitted to answer. If I sustain the objection, there is no answer and therefore no evidence. Remember that a question alone is not evidence. If the lawyer objects after the witness has answered the question and I overrule the objection, the answer stands as evidence. If I sustain the objection, the answer is not evidence. The question and answer are stricken from the record, and you are to completely disregard the answer. In any event, any ruling by the court on an objection of counsel or otherwise is based on our law and expresses no opinion about the facts of the case or whether the defendant is guilty or not guilty. Remember, you are responsible for that decision. Now, from time to time during the course of the trial, there will be conferences at the bench with counsel if necessary. And if those become prolonged, the court may and the parties may need to excuse ourselves for a short period or ask the jury to return to the jury room for a time. These conferences deal with matters of law or scheduling that are my responsibility. So when the occasion does arise, when there are conferences at the bench or outside your presence, I ask you to be patient and understanding while those are conducted. Upon completion of the presentation of evidence, lawyers will then address you in a closing statement, or what our law calls a summation. What a lawyer says in summation is not itself evidence. The summation is, however, provide each lawyer an opportunity to review the evidence presented and submit for your consideration the facts, inferences, and conclusions which they contend may be properly drawn from the evidence presented. After the summations are concluded, I will instruct you on the rules of law applicable to the case. You must accept and follow those rules. You will then begin your deliberations. During your deliberations, your function as jurors will be to decide what the facts are and to apply the rules of law that I set out. You will determine what the facts are from all the testimony you hear, the exhibits that are submitted, and any stipulations that the parties have agreed to. In other words, you will decide the case based on the evidence. The conclusion you reach from determining the facts and applying the law will be your verdict, be it guilty or not guilty. Now, under our law, juror number 1 will serve as the jury's foreperson. During the trial, the foreperson has the same responsibilities as any other juror. During deliberations, the foreperson will sign any note that the jury sends to me, including that the jury has reached a verdict, and the foreperson will announce the jury's verdict. Thus, in sum, the stages of a criminal trial are, first, the openings, followed by the presentation of evidence, summations, final instructions of the court to the jury on the law, and then finally, the deliberation of the jury and the verdict. Now, again, I will remind you that this case has garnered some media attention, and you may have observed some of that. If you have, you must put that out of your mind entirely, as this case must be decided based only on evidence presented here at trial. It is not inherently a problem if you kept up with the news and learned something about this case. In fact, it's desirable to have thoughtful, informed jurors who take an interest in their community. However, any information you learned outside this courtroom or any opinions you may have formed must be set aside and disregarded by you now. The news media is a wonderful institution and plays an important role. Reporters are human beings that sometimes make mistakes and sometimes are only in a position to report part of a story and may lack critical information. If you formed an opinion based off of that, then you would have a flawed, only partially informed opinion. Accordingly, you must now, throughout this trial, put aside any information and opinions you may have previously formed and decide this case solely based on the evidence presented here in court and the law as I give it to you. I am also aware that video relevant to this case has been released in the media, and some of you may have seen that. Again, if you have, you must disregard what you have previously seen and any opinions you may have formed as a result. Consider whatever you viewed outside the courtroom does not constitute evidence. It has not been vetted nor authenticated. You have no way of knowing if what you saw was all or just part of an original recording. You have no way of knowing if what you saw was clipped, edited, or manipulated in some fashion. If you formed an opinion from such video, you would then have a flawed, misinformed opinion. For that reason, you must again, now and throughout the trial, put aside any information and opinions you may have previously formed and decide this case solely based on the evidence presented here in court and the law as I give it to you. During this trial, if you need to speak with me about something relating to your jury service or the trial, please tell a court officer that you need to speak with me. I will then arrange an appropriate meeting with the parties here in the courtroom. Do not discuss with your fellow jurors whatever you feel necessary to bring to my attention, and then after we've had our conversation, do not discuss with your fellow jurors whatever it was we discussed. During a trial, we do our best to avoid delay. From experience, I know that delays are inevitable for a variety of reasons through no one's deliberate fault. Should such delay occur, I ask for your understanding and patience. And you also request that you be here at the times I set so that the absence or lateness of a juror is not itself occasion for delay. I will ask you to give a phone number to our court officer in which we can reach you if for some reason the trial schedule were to change. Now, if an emergency arises, will make you late or prevent you from attending, please call the court, leave a number where you can be reached, and explain the problem so we can minimize everyone's inconvenience. Before you leave, a court officer will give you the phone number here for the court. Additionally, I do want to advise you that no one involved in this trial, if the attorneys, defendant, or witnesses, should be speaking with any of you jurors outside the formal conduct of this trial. Now, the reason for that rule is that even innocent clothes, and small talk can give rise to the appearance of impropriety. So if you encounter one of the attorneys or someone involved in this trial outside the courtroom, you do not get friendly hellos or conversation back from them. Please understand that no one is being rude or impolite. They are simply following the rules that are expected of them. Now, we've selected alternate jurors in this case, and an alternate juror is expected to pay the same close attention to the case as any one of the 12 jurors. The only difference between an alternate juror and one of the 12 is that the alternate juror does not know at this time whether that juror will be called upon at some point during the trial to substitute for one of the 12 jurors. For everyone's information, that substitution can take place only if some presently unforeseen extraordinary emergency arises that makes it completely impossible for one of the first 12 jurors to complete the trial. Our law expects the first 12 jurors who begin the trial will be the same 12 jurors at the end of the trial, so it does take an extraordinary emergency before there may be a substitution of an alternate. Finally, our law requires jurors to follow certain instructions in order to help assure a just and fair trial. I will now give you those instructions. First, do not converse among yourselves or with anyone else about anything related to this case. You may tell the people with whom you live and your employer that you are a juror, and you may give them information about when you will be required to be in court. You may not talk with them or anyone else about anything related to this case. Second, do not at any time during the trial request, accept, agree to accept, or discuss with any person receipt or acceptance of any payment or benefit in exchange for supplying information concerning this trial. Third, you must promptly report directly to me any incident within your knowledge involving an attempt by any person improperly to influence you or any other member of the jury. Fourth, do not visit or view the premises or place where the charged crime is allegedly committed, or any other premises or place involved in the case. And you must not use internet maps or Google Earth or any other means to search or view any location that may be discussed in the testimony. Fifth, do not read, view, or listen to any accounts or discussions of the case reported by newspaper, television, radio, on the internet, or any other form of media. And sixth, do not attempt to research any fact, issue, or law related to the case, whether it be by discussion with others, research in the library, on the internet, or by any other means or source. In this age of instant electronic communication and research, I want to emphasize that in addition to not conversing face-to-face with anyone about the case, you must not communicate with anyone about the case by any other means, and that includes by telephone, text message, email, or social media websites such as Facebook or Twitter. You must not provide any information about the case to anyone by any means whatsoever, and that does include posting information about the case or what you're doing in the case on any device, internet site, including social media or any other means. You also must not Google or otherwise search for information about the case or the law which applies to the case or the people involved in the case, and that includes the defendant, the witnesses, the lawyers, and the judge. And now briefly, ladies and gentlemen, I want you to understand why these rules are so important. Our law does not permit jurors to converse with anyone else about the case or to permit anyone to talk to them about the case, because only jurors are authorized to render a verdict. Only you have been found to be fair, and only you have promised to be fair. No one else has been so qualified. Our law also does not permit jurors to converse among themselves about the case until the court tells them to begin deliberations, because premature discussions can lead to a premature final decision. Our law also does not permit you to visit a place discussed in the testimony. First, you cannot always be sure that the place is in the same condition as it was on the day of question. Second, even if it were in the same condition, once you go to a place discussed in the testimony to evaluate the evidence in light of what you see, then you become a witness, not a juror. As a witness, you may now have an erroneous view of the scene that may not be subject to correction by either party, and that is not fair. Finally, our law requires that you not read or listen to any news accounts of the case, and that you not attempt to research any fact, issue, or law related to the case. Your decision must be based solely on the testimony and other evidence presented here in this courtroom. It would not be fair to the parties for you to base your decision on some reporter's view or opinion, or upon some information you acquired outside this courtroom. These rules are designed to help guarantee a fair trial, and our law accordingly sets forth serious consequences if the rules are not followed. I trust you understand and appreciate the importance of following these rules, and and in court with your oath and promise, I know you will do so. We will now turn to the opening statements. The court will recognize for the prosecution, Mr. Fitzpatrick.
Thank you very much, Judge Ballard. Good morning, ladies and gentlemen, and thank you for your kind attention during jury selection. You know, we live in a country where we can't agree on anything anymore, and yet a series of very experienced lawyers all agreed that you would be great jurors. And I'm holding you to that. I'm holding you to your word on what you promised us during the voir dire process. And I hope you're as anxious as I am to get to the facts of this case. What I'm about to do now is not evidence, of course. I was not there. I will present to you what we intend to prove over the next 24 to 48 hours. And it's my honor, frankly, to be here in Oneida County to prosecute those for this senseless, this tragic, this evil, this reprehensible, and ultimately criminal death of a 43-year-old, 148-pound man by the name of Robert Brooks on December the 9th, 2024. That was a date that was the last day of Robert's life, and it was also a date where, at least here in Oneida County in the emergency room of the Marcy Correctional Facility, human decency and humanity itself took a holiday. Robert was one of about 32,000 men who are incarcerated in the state of New York. We incarcerate people to punish them for what they've done, and we also have that underlying hope that when they're done with their sentence, they'll be rehabilitated and they'll come out of that correctional facility better than when they went in. Robert had that chance taken away from him. He had originally been at the Mohawk Correctional Facility in December. He was involved in a number of altercations there in the days preceding his death. The medical evidence will indicate very clearly to you that these prior incidents had nothing whatsoever to do with his cause of death. It was decided by authorities that on December the 9th, to alleviate these altercations, he would be transferred to the Marcy Correctional Facility. That evening, he packed up everything he owned in life in a duffel bag, got on a bus, and at 9:07 p.m., he was dropped off into the custody of corrections officers at the Marcy Correctional Facility. 30 minutes later, he was dead. For no discernible reason whatsoever. Everybody sitting in front of me must have a residual thought that he spit at somebody, that he cursed at somebody, that he denigrated somebody's family, that he punched a corrections officer. The reality of it is, he didn't do a damn thing, and he was beaten almost immediately. Now, according to standard procedure, when an inmate is brought into a facility, Marcy included, he is to be brought to the infirmary to be examined. At this time, apparently the standard procedure was to beat him before he got into the emergency room and the infirmary. He was brought in there hogtied like an animal. He was beaten before they even brought him in there. Michael Fisher, the defendant here, is a 20-year veteran of corrections in the state of New York. He was several dozen yards away when this incident started. He was very busy watching a Tom Cruise movie that ironically enough has something to do with a man being transported back in time so he could correct his past mistakes. And at 9:21 p.m., 21:21, a call goes out suggesting that certain corrections officers needed assistance. In reality, the only person needing assistance that evening was Robert Brooks, who was about to be beaten to death. You will see Mr. Fisher taking, frankly, a leisurely stroll from his position over to the infirmary. It takes him several minutes. He's not running, he's not rushing, he's not hurrying. He doesn't appear to be on his radio getting further information. He's just walking over to the infirmary. We'll show you the route that he took by videos and diagrams. He enters the infirmary, and I'll use two expressions here, ladies and gentlemen. Infirmary is the building itself. The emergency room is the room inside the infirmary where Robert was eventually killed. Mr. Fisher enters that building, the infirmary, at approximately 9:25:20 p.m., and he remains there for the most part until approximately 9:41:40 p.m. And during that 16-minute period, there are two things that I will prove to you with absolute certainty. Number one, Robert Brooks was beaten to death right in front of this defendant. And number two, he did nothing to assist, intervene, to stop it in any shape, manner, or form. 20 years on the job, and he stood there and watched a man's life being snuffed out. Yeah, he did a couple of things. He moved some leg irons. He put on some rubber gloves, but he never intervened. He never said enough. He never shielded Robert. He never got medical assistance for him. He never got animated. He never said, "That's enough. I'm turning on my camera." 7 words that could have saved this man's life, and he didn't even take the 4 seconds to utter those 7 words. The only function he served was that after this horror show ended, he goes back and finishes watching his movie. This, ladies and gentlemen, is the count of the indictment that I must prove to you. Manslaughter in the 2nd degree, with the addition of criminal liability for the conduct of another in violation of sections of the penal law of the state of New York that on or about the 9th day of December in the town of Marcy in this county, the defendant recklessly caused the death of Robert Brooks, to wit: defendant was present in the infirmary emergency room and the emergency doorway during significant periods of time during the beating of Robert Brooks, and defendant had a clear line of sight to see and hear the beating, being aware of the risk that the beating by other corrections officers could result in the death of Robert Brooks, and having a duty to intervene, defendant did not in any way attempt to stop the beating and did not in any way attempt to shield Robert Brooks from the onslaught. I will prove those facts to you not only beyond a reasonable doubt, I will prove them to you beyond any doubt. Now, as critical thinkers that I anticipate you are, I suspect that you are saying, Mr. Fitzpatrick, how do we know? How are you going to prove to us what Mr. Fisher saw? Well, what these geniuses didn't know was that even though they were violating multiple rules,
There's an objection.
Objection to characterization.
Sustained as the characterization.
I apologize for calling them geniuses. I didn't want to call them corrections officers because they stopped being corrections officers at 9:07.
There's an objection. Yes, Mr. Marcy.
Mr. Fitzpatrick is being, can we approach our?
Judge, I would like to conclude my statement in an orderly fashion with the jury.
The last objection is sustained. Jury will disregard. Go ahead.
What they didn't know, despite the myriad rules that they were violating, that their cameras were recording. You will see the passive recording of 30 minutes of 2 and possibly 4 corrections officers, one of them being this defendant. Michael Fisher, his own view of what he saw. And keep in mind that the body-worn camera is at chest level. It's several inches below his eyesight. So you will see an approximation of what he saw, but it'll be very clear what in fact he saw. So how is it that someone who demonstrably never touched Robert Brooks can be responsible for his death, criminally responsible? There's an old cliche, I'm glad this came up during voir dire, there's an old cliche about morality. People say, pontificate on talk shows, and they say, well, you know, you can't legislate morality. And some professor will nod his head as if he said something profound. Well, that's false. That's exactly what we do as a society.
Objection.
Yes.
The jury is not making a moral judgment.
Judge, I will cover that in my opening statement. I apologize.
You're not making that type of opening statement. That's
Counsel,
moral.
Counsel. Yes.
As I was saying, we absolutely do legislate morality as a society. What is immoral is not necessarily criminal, but everything that we decide is criminal is immoral. I'll give you examples of that. Apparently on voir dire, both sides agree that the actions and inactions of Mr. Fisher are immoral. I am not prosecuting him for being immoral on December the 9th, 2024. I'm prosecuting him for being a criminal on those dates. Some examples are easy. Every society that we know of has decided that murder is immoral, and we will make that criminal. At some points in our past history, we have made immoral things criminal that should not have been criminal. Homosexuality. In 9 countries on the planet, it is illegal to be homosexual. Thank God we live in the US of A, and we recognize people's rights to exist consistent with their decisions and their choices. Adultery is immoral in almost every society. It used to be a crime. When I started as a prosecutor, there was a crime on the penal law books of adultery. And we recognize that that is something immoral that should not be criminal. But we do make some level of morality part of our responsibilities as New Yorkers. And one thing that we recognize that is both moral and legal is a duty to intervene. Only in certain circumstances. Judge Bauer will discuss that with you at the end of this case. For example, if you're driving on the thruway and you pass a car that appears to be on fire, and there are occupants of the car, it might be a moral thing to stop and render aid. But if you decide not to and drive on, you have committed no crime in the state of New York. You see a person being attacked in Central Park. You have no duty to intervene. You may choose to do so heroically, but let's change the facts ever so slightly. Let's say that that person in that car is your child. Let's say that your child is doing something dangerous. You have a duty to intervene. It comes down to a duty of care imposed by the law. And I assure you, there is no population more dependent for their nutrition, their hygiene, when to retire, when to wake up, their personal safety, their recreation, when and where they can congregate and get together, then incarcerated individuals are dependent on the duty to care on corrections officers. In short, their virtual entire existence is dependent on the service of New York's corrections officers. And let's get something out of the way right now, okay? Yes, it is a difficult job. It is a dangerous job. Some incarcerated individuals are evil, despicable people that would kill a corrections officer as soon as they would look at them. They have weapons that are on occasion are snuck into a facility. We get that. I get that. That's why we pay them. That's why we pay them overtime. That's why we give them health benefits. That's why we give them pensions. Yes, it's a difficult job. That is not an issue. But last time I checked, having a difficult job is not carte blanche to divorce yourself from the human race. You will look at the tape of Mr. Brooks being beaten to death. You've already been warned by defense counsel that you may be repulsed by looking at that tape. But you're not a 20-year veteran of the New York State Department of Corrections who took an oath, as you did, only more intense, to support the Constitution of the United States, to uphold the laws of the state of New York, to recognize that he has a duty to intervene, not to stand there and watch without protecting, without serving, and without even taking a millisecond to turn on his body-worn camera. Why is he before the bar of justice today? What is the proof that the people will present? Did Michael Fisher recklessly cause the death of Robert Brooks? You will be a changed person by seeing the tape of what he saw and what he didn't do. He enters, Mr. Fisher, enters the infirmary at 9:25:20 p.m. Mr. Brooks is already bleeding profusely from his face. He is on a bed or gurney with his legs dangling from the end of that. He sat up. He's got cuffs on. He's surrounded by corrections officers. Mr. Fisher has a clear view of everything I'm about to describe to you. Did he engage in conduct which created a substantial or contributed to a substantial and unjustifiable risk that Robert Brooks' death would occur? In clear view, Mr. Fisher watches the following occurred. He is struck multiple times about the head, the torso, the body, his neck. You will see a corrections officer, while Mr. Fisher is standing 5 to 6 feet away, extend his left leg up onto the gurney and forcibly jam the testicles of Mr. Brooks to the point where they're damaged and causing unbelievable pain to that man. He's standing right there watching that. Sadly, you're going to have to watch that too. And you'll also see in the tape, particularly for Mr. Fisher, where you look at his face, because you'll see another corrections officer's camera that catches Mr. Fisher, there's a look of normalcy. There's a look of routine, almost calm, as these despicable acts are taking place. Did he consciously disregard the risk? Of course he did. Was the risk of such nature and degree that disregard of it constitutes a gross deviation from the standard of conduct that a reasonable person would observe in the situation? Of course it was. It will be painful for you to watch. You will be sitting there watching this in the serenity of this courtroom, and you will be horrified and disgusted by what you're watching. It will come to your mind to shout out, "Stop!" He's not an animal. He's an incarcerated individual. He's in our care, our custody. As citizens of New York, stop doing that. That's what you will think. He does nothing. You will see from Mr. Fisher's point of view, his direct ability to view, another CO violently grabbing Robert's neck and choking him, and still no response. You'll see him walk into the hallway, casually conversing with other spectators. I won't call them corrections officers. They'll have badges on. They'll have American flags on their sleeves, and they will dishonor both. At 9:28:40 of his tape, you will see Mr. Fisher putting on blue surgical gloves, getting ready to join in. And you will see, as he saw, Mr. Brooks dragged off that gurney by his neck and taken into a corner of the emergency room so he can be further assaulted and killed. Did Mr. Fisher cause the death of Robert Brooks? Of course he did. I would use the example, as I did on voir dire, of a person shot in the head. Obviously, that person who pulled the trigger has caused the death. But under the law, so does the person who hands him the gun. So does the person who has a duty to intervene and does nothing. The parent that lets a child enter a dangerous situation, knowing that danger lurks, and the parent does nothing. That parent is just as guilty as Mr. Fisher. If you saw this happening to a neighbor's dog, what I'm about to show you.
Objection, overruled. However, ladies and gentlemen, do recall that what you're hearing right now is what counsel anticipates the proof will show. It is not itself evidence.
If you saw a neighbor's dog being treated like these corrections officers treated Mr. Brooks, would you have tried to stop it? Would you have tried to film it? Would you have at least called 911? And you don't have 20 years on the job of supposedly protecting other people. He did none of those things. Medical assistance wasn't even called until he's left, going back to his station to finish his movie. He looks in on various occasions on Mr. Brooks. You'll see Mr. Brooks dying. You'll know that he's dying. And he says, I had no idea. You won't see concern on his face. You'll see him, believe it or not, you'll see him smiling as he stands in that emergency room. He had over 6 minutes, over 6 minutes, directly in that room. Of his legal duty to intervene, you will have no doubt. Another element I must prove to you, and that is whether Mr. Fisher consciously disregarded that a risk of death could occur. Was it foreseeable? The proof is going to show, of course it was foreseeable. He's dead. How much more foreseeability do you need? Doesn't mean you have to be Nostradamus. Doesn't mean it has to be the only possibility that could have occurred. Was it foreseeable? Yes, it was. Not required that he intended to cause his death, not required that he thought they were going to kill him, but was it foreseeable? He wasn't slapped. The evidence isn't going to show that he was gently moved by these corrections officers. He was yanked around, he was punched, he was kicked, he was the things that you're not going to believe them when you see them. He was beaten to death right in front of this defendant, and he had over 360 seconds to do something about it. The final witness you'll hear from is the medical examiner, Dr. Merkulova, who performed the autopsy. She will describe to you, they say dead men tell no tales. That's not true. Dead men tell lots of tales. And Robert Brooks will tell you in death what happened to him while he was still clinging to life. She will tell you that he died from multiple blows. Not one single blow, but multiple blows over the course of several minutes while Mr. Fisher was standing there doing nothing. The blood was diverted from his major organs because of the blows to cover the pain that he was suffering to these injuries. How his neck was eviscerated. The bones in his neck were broken. He choking on his own blood. Multiple blows, any one of which this defendant could have stopped. Of course he was aware of the risk. And you'll see, don't forget, you'll see what he saw, but you won't hear what he undoubtedly heard. So based on the evidence, is he a neophyte? Will the evidence show that he's just some rookie that didn't know what was going on? No. Will the evidence show that he had no idea because he's deaf, dumb, and blind? No. He was there. He saw it. The simplest, most clear-cut, honest explanation is the best. That he knew and should have known that there was a risk of death and that he recklessly, by omission, did nothing. He made a clear decision to abandon his oath on December the 9th, 2024. And I remind you, you are not to consider what happened to the others. You are not to consider punishment. That is in the province of Judge Bauer. You should consider accountability. You should consider human decency. You should consider the law. And you should consider justice. Justice for Robert Brooks and justice for the people of the state of New York. Our great country is replete with examples of men and women doing extraordinary things, performing heroic acts of courage in their lives. I don't care if it was a bunch of farmers in 1776 that beat the greatest military on the planet Earth at the time, or whether it was a bunch of soldiers at Gettysburg that turned the tide of the Civil War, or whether it was a bunch of kids from Nebraska and Kansas and New York that climbed the cliffs at Normandy when German machine gun was raining down upon them. They were ordinary people that did heroic, incredible things. And they weren't 20-year veterans of the Corrections Department of the state of New York. History will not record Mr. Fisher's inactions as heroic. You will record them, and we will prove to you that they were exactly what they were: absolutely criminal. And I will ask you, I will beseech you to return the only proper verdict in this case, that this man is guilty of manslaughter in the second degree. And I thank you for your kind attention.
Thank you, Mr. Fitzpatrick. Mr. Eisman, do you wish to make an opening?
I do, Your Honor. Thank you.